Ladies and gentlemen, this is Advocate Somnath Banerjee from evakil.com. In the vast courtroom of life, where justice is the ultimate goal, I stand behind you as the custodian of justice and to uphold truth before the court of law. Many a person in many cases asks me a very simple question that in case of divorce in India, how to approach the learned court of law. And people usually get very much stigma in their life while going to court and to follow up any procedure. They have so many doubts and questions so that they even don't bother to take legal help so that they could get themselves in a better position without getting any further harassment what already pain they are facing in their life. So the first question which we have to answer, that is how I should proceed when there is a problem between husband and wife. The first thing what you have to do, you have to find out that how your partner is reacting. If it is a mutual divorce, the process is easier. Both the partners, they have to first choose their learned counsels, and after discussing with them on mutual grounds, both the parties at the same time will jointly file a mutual divorce petition before the learned court. After filing that petition, usually court gives a small time for mediation between the parties, because all the courts in India, they first try to protect any of the relation, and for that this mediation program is held. Now if mediation is failed, thereafter the court gives a time in which both the parties have to appear and to file their evidence, and in that day or some other, the learned court gives the order of divorce, and followed by that order the decree of divorce comes, and this entire process takes usually 6 to 9 months of time to complete. But if it is a contested divorce, it becomes a bit more problem creating thing for the parties to face, but really you are not alone. Many a persons face this type of problems, but these problems can easily be sorted out. Usually a contested divorce takes 3 to 4 years of time, and the first thing you have to do is to describe in detail your entire problem before the learned advocate whom you choose, and he will decide how to draft your petition and settle it. Once the petition is settled, it will be filed before the learned court, and the opposite party will be communicated with the petition, and he or she will come and file his or her written objection before the learned court. Thereafter the court will take evidence, and after the evidence part is completed, both the parties' learned advocates will argue the case before the learned court, and followed by the argument, if your case is genuine, the court will pass the order of divorce, and followed by the order of divorce, the decree of divorce will come. So really the process is not that difficult as we generally think. Mainly in India, Hindu, Muslim and Christians, they have their own personal laws. Hindus sometimes marries under Hindu Marriage Act, Muslims under Muslim laws, and Christians in their own laws. But generally a very common law is Specific Marriage Act. Under Specific Marriage Act, any of all these religions they can marry, and all these legal procedures ultimately, even they have their own respective acts, the process of divorce is all the same. And in this entire process, what I have already discussed before you, the conciliation program first take place, because court usually thinks not to break any relation without giving couples chance to mediate and to further rejoin together by not destroying the relation. And if this mediation fail, then only the primary divorce process and the secondary divorce process, that is argument, takes place, and the decree of divorce order and the decree of divorce comes. So if for any further assistance, if you want to consult us, just visit our website and take all the detailed information so that we can help you in this process.